So let's look at the same deal, but structured with asset protection in mind. If we had done the deal, if this had been one of our clients and he had come to us before the deal was structured, we would have recommended that he accept the 10% interest. That's fine. The limited liability company will often work as planned, and theoretically, he should have had the protection. However, we wouldn't have had him hold it in his name directly. We would have had him hold it in what's called an asset management limited partnership. Now this is Mr. Target's entity. This is his deal. This is for his personal assets. It does not involve unrelated parties. It's going to involve his family members, and that's it. So his 10% interest wouldn't be held as the other guys had held it, and as he had held it in the original deal. It would have been held by another company. Now here's the advantage of this. Let's assume the same thing happens. The deal goes bad. We have the judge sitting over here in Florida trying to break through and hold the partners individually liable. What he would find out is that when he got to this partner, it wouldn't be an individual. It would be another entity. And it's not going to be a Florida entity. It's actually going to be an entity most likely in the jurisdiction of Arizona, possibly in Nevada, possibly in Delaware, depends on the circumstances. But in any case, it's going to be in a state that has very clear statutory rules around who and when can get into the assets of this partnership. So what the judge in Florida would have discovered is that he can no longer now just say, Mr. Target, I'm holding you responsible. He's got to hold Mr. Target's asset management limited partnership responsible. And if they want to even try to get into that, they're going to have to fly to the jurisdiction of this entity, which let's assume is Arizona. So they fly to Arizona, they're going to have to go through the argument again, and it's going to be very difficult and very unlikely that an Arizona judge is going to pierce this corporate veil a second time. However, that's not the end of the line. We don't even rely on that. So let's say the facts are extremely horrendous here. We had a lot of fraud, mismanagement, whatever. And the Arizona judge is looking wobbly for any reason whatsoever. We actually decide, wow, the entire US system is not something I'm comfortable relying on. This is where the real key to all asset protection planning comes into play. And that's called the International Asset Protection Trust. That's up here. This trust is going to serve as the 98% limited partner of Mr. Target's Asset Management Limited Partnership. Who's the general partner? Well, it's going to be Mr. Target himself. Or Mr. Target's own individual LLC. Again, depending on circumstances. So if we look like, for any reason, this entity could also get pierced, we're going to do what's called triggering the trust. What happens when we trigger the trust is the assets will actually physically move from this entity to this entity. This entity is a totally different animal. First of all, it's registered in a jurisdiction outside of the United States. The capacity for someone to even attempt to get into that trust is difficult to say the least. The rules are completely different. And so these judgment creditors from all the way back here in Florida, if they can even get through Arizona, already unlikely, then they look at facing a completely foreign jurisdiction where they do not accept contingent fees, where their current plaintiff's attorneys cannot practice. The whole rules of the game change. Now, here's where asset protection really works. And this is what asset protection is all about. It's deterrence and it's leverage when it comes time to settle. And that's what this is all about. So in this case, we've got this $1.6 million judgment. Instead of seeing the assets of Mr. Target just sitting there behind Mr. Target, these judgment creditors now see a structure that is virtually impenetrable. And I will say that never has one of my trusts ever been penetrated. And the whole negotiation changes. Now they're looking at Mr. Target and saying, we're probably not going to get anything, let's settle. And that's what it's all about. This is a game of cat and mouse. The US legal system is the playing field, and this is your ultimate defense. Now, if you'd like to know details about triggering, some of you listening will actually have caught that the issue of how do you trigger this after there's been a lawsuit. Suggest you watch the other videos on YouTube called When Can I Trigger My Trust and What is Fraudulent Conveyance. Hope this has been helpful. Look forward to our next case.